Speaker, I rise to speak on the Evidence and Other Legislation Amendment Bill 2021. Queensland is currently the only jurisdiction in Australia without any legislative shield law protections, meaning journalists can be forced to disclose the identity of their sources or risk facing a substantial fine or even jail time. For any democracy to thrive, Deputy Speaker, the free availability of information is crucial. Without this, journalists won't keep people informed on matters of crucial public interest. Sources who leak classified documents and information to journalists do so to expose wrongdoings of power, whether governmental, bureaucratic or corporate. Such people have little to gain and everything to lose in doing so. Journalists too put themselves at risk when protecting the identity of sources and their information. As things currently stand, there is little in Queensland's common or statute law to protect either of them. Speaker, Queensland has become a very secretive place with many restrictions in place preventing public access to vital information that is in their interest to know. The current pandemic has greatly accelerated this trend towards secrecy. Pandemic modelling is deliberately withheld from the public on the basis that the ordinary person, like children, incapable of understanding or likely to misrepresent it. This is unacceptable. It has meant that bureaucratic health committees and other government agencies have been left free to operate without any public transparency or oversight by parliaments. The people of Queensland deserve much less secrecy and better protections for their journalists. If sunlight is the best disinfectant, then these things are getting darker and darker in Queensland. The various attacks on journalists the last few years are an affront to our democracy. Throughout this time, there has been a steady erosion of our rights and freedoms, something the mainstream media, to its discredit, has been largely silent on. One journalist even tried to assert last year that Julian Assange was not entitled to the same rights as other journalists because he is not a real journalist. Whatever you may think of Julian Assange, he is definitely a real journalist and entitled to all the same rights as other journalists lay claim to. For all the government's lofty sentiments about the bill providing Queensland journalists with shield laws, there are a number of major loopholes which render all its purported protections tokenistic at best. Chief among these loopholes is the bill's significant caveat which allows the shield law protections to be waived if a judicial officer decides it is in the public's interest to do so. So what the left hand gives, the right hand will take away. There is no criteria or a set of rules that a judge may adhere to when determining whether something is of public interest or not. In the UK and the EU courts work under the presumption that journalists are not required to reveal confidential information, full stop. New Zealand operates under the same presumption. Without strong and effective shield laws, you simply won't have sources willing to come forward or journalists prepared to publish them, no matter how vitally important to the public interest that information is. A much bigger get-out clause in the bill is Clause 14S, Section 2, which excludes the Crime and Corruption Commission. The main reason these shield laws were needed in the first place was because of the way the CCC's extraordinary and secretive powers have been used to intimidate and coerce Queensland journalists into divulging their information and sources. The recent proceedings against F is just one of the many cases which reveals just how badly shield laws were needed in Queensland to protect journalists from the CCC and its Star Chamber proceedings. Shield laws that exclude the CCC will mean Queensland journalists remain a significant risk of being forced to reveal their sources and of being imprisoned if they refuse. I therefore urge the Attorney-General to reconsider the exclusion and extend the shield law protections to include the CCC and all its proceedings. I also note there is no provisions covering bloggers or citizen journalists contained in the bill. This is another serious omission in my view. These and other limiting clauses in the bill make it hard to see how these new shield laws offer journalists anything in the way of real protection or rights. In my view, the government would be better off looking at the old shield provisions contained in the Commonwealth Privacy Act. Under the Act, the journalist can be fined or imprisoned for failing to provide information, answer a question, produce documents, except where he or she testifies that doing so would reveal the name of a source who had supplied the information confidentially. No ifs, no buts, just straight-up protection. That's what we need. That's the sort of shield laws Queensland journalists do need, not Swiss cheese varieties like this bill's offering. A strong and protected fourth estate is essentially a healthy and open democracy. The bill does not adequately reflect Queensland's commitment to this principle. the relevant provisions which I have just highlighted must be redrafted to better protect Queensland journalists and the public's right to know.